I'm attorney Emily Anderson with RSH Legal. Recently, members of the Iowa legislature voted in major changes to Iowa's workers' compensation system. Unfortunately, these changes do not benefit injured workers. They benefit employers and insurance companies. Some of these changes have created gray areas in how the law will be applied. The courts will have to sort out those legal issues, which will likely take several years. In the meantime, injured workers will be navigating a new system that is lopsided in favor of employers and insurance companies. Before we get to some of the changes, first, a word about who these changes affect. The legislation went into effect on July 1st, 2017. That means injuries before July 1st, 2017 will be governed by the old laws. On the other hand, injuries that happen after July 1st, 2017 will be governed by the new laws. There are a few changes that will impact workers who were hurt even before July 1st, 2017. For cumulative trauma injuries, injuries that come on over time, the date of injury can be a moving target. You should talk to an Iowa workers' compensation attorney to determine the proper date of injury that applies to your claim. How much compensation you receive may vary greatly depending on whether your claim is governed by the old or new law. That is why your date of injury is important. Now to the major changes. First, shoulder injuries. If you suffered a shoulder injury after July 1, 2017, the amount of permanent disability benefits you are entitled to has been reduced drastically. To understand this, you have to know a bit more about how different work injuries are compensated in Iowa. Where on your body you are injured impacts your compensation greatly. Your right to medical benefits and temporary benefits are not impacted by the location of your injury, but the amount of your permanent disability benefits are. There are two categories of injuries in Iowa: scheduled injuries and body as a whole injuries. Scheduled injuries are injuries to limbs and the eyes. Each body part is assigned a maximum amount of weeks a worker can receive in permanent disability benefits for an injury to that scheduled member. After an injured worker is released from the doctor, a doctor will give the worker an impairment rating. The rating comes in the form of a percentage and is supposed to reflect the level of impairment to that limb caused by your work injury. In scheduled injury cases, that rating or percentage dictates how much permanent disability benefits an injured worker receives. For example, Iowa workers' compensation law says that an arm is worth a maximum of 250 weeks of permanent disability benefits. If an injured worker's arm is cut off, he gets the whole 250 weeks. If the arm is only partially injured, he receives a percentage of 250 weeks. So if the doctor assigns a 10% impairment rating, the injured worker is entitled to 25 weeks of permanent disability benefits. This is true regardless of how the injury impacts the worker's ability to work going forward. Because the impairment rating, and not an injured worker's loss of earning capacity, dictates how much is owed for a scheduled injury, this law can produce really harsh results in some cases. A body as a whole injury is an injury to any body part that is not on the schedule. Typically, this is an injury to your neck, back, spine, shoulders, hips, or head, or a mental health disease. These injuries are worth either a percentage of 500 weeks, or if you cannot return to work at all, then lifetime weekly benefits. If you have a body as a whole injury, how much you receive in permanent disability benefits depends on how your injury has affected your ability to earn. The physical impairment rating is only one piece of the puzzle in determining how much you are owed. For example, if you hurt your back and receive a 10% physical impairment rating, but you have lifting restrictions that make it so you cannot go back to your old job, you are not limited to the 10% or 50 weeks. Instead, you are likely entitled to something more because your ability to work has been affected. Now that you have that background, let's talk about the change to shoulder injuries. Shoulder injuries used to be body as a whole injuries, where you would be compensated on the basis of your loss of earning capacity. With the change in Iowa workers' compensation law, shoulder injuries are now scheduled injuries. The shoulder is worth a maximum of 400 weeks of benefits. How many weeks an injured worker receives for a shoulder injury is now solely dependent on the impairment rating. So if your doctor assigns your shoulder a 10% physical impairment rating, you will receive 40 weeks of benefits, even if you can't go back to work. Again, this is a very harsh result because shoulder injuries quite often are career-ending or at least career-changing work injuries. Let me give you a real-life example of how harmful this new law is. I represented an injured worker who had been a nurse her whole life. Due to a work injury, she had to have her shoulder replaced. As a result, her doctor gave her serious physical restrictions, including she could not lift over 5 pounds. The employer fired her. She applied for over 100 jobs after her injury and was not able to find work. The judge found that the work injury made it so she could not work anymore, entitling her to receive a weekly workers' compensation benefit check for the rest of her life to help her replace her lost wages. With the new law in place, that same nurse would receive only 100 weeks of permanent disability benefits, less than 2 years, instead of a weekly check for the rest of her life. Depending on where you were hurt in your shoulder, your injury may still fall under the body as a whole category. It's very important to talk to an experienced workers' compensation attorney if you have a shoulder injury and not just take the insurance company's word for it that you have a scheduled injury. If you return to work or your employer offers you a job at the same wage, even if you cannot actually perform the work offered, the amount of your permanent disability benefits is limited by the law to your physical impairment rating. This is true even if you have a body as a whole injury. This change essentially transforms all injuries into scheduled injuries if your employer offers you work at the same wage. If the employer offers you a job but then later terminates you, you can reopen your workers' compensation claim and seek additional benefits. This provision in the law will likely become very important for injured workers going forward. Let me give you an example of how this change is harmful. We represented an injured worker with a serious back injury. His employer brought him back to work, but because of his permanent physical restrictions, he couldn't go back to his old job. So his employer gave him tasks like checking the power outlets in the plant to make sure they still worked, making sure the fire extinguishers were not expired, and even sitting in the break room. This was his job day in and day out, and as you can imagine, it was harmful to his mental health. He developed major depression. Even though this injured worker suffered a debilitating injury, the employer made up a job for him. The workers' compensation judge recognized that this job was not a real job and awarded the injured worker 300 weeks of permanent disability benefits. Under the new law, the judge would not have had that option unless the injured worker had been fired. The injured worker would have been limited to 55 weeks of permanent disability benefits, the equivalent of his physical impairment rating, and just over 1 year of benefits. There are multiple other changes to the law. These changes include a new hurdle to receiving benefits if the employer claims you were intoxicated, decreased interest owed on benefits not paid on time, a gap between when the doctor releases you from care and when you start receiving permanent disability benefits, a loss of certain benefits if you don't comply with an insurance company's request to see one of their doctors, and you can no longer receive all of your future benefits in a lump sum. That change actually applies to all injured workers, regardless of when you were hurt. So what is not changed about Iowa workers' compensation law? The 4 basic types of workers' compensation benefits still exist. There are medical benefits to cover medical expenses related to your work injury. This includes mileage to and from your appointments. The employer still gets to choose the doctors even under the new law. Temporary disability benefits, which are designed to help replace your wages when you are still healing from your work injury and a doctor has restricted you from working completely or has placed you on a restriction that work cannot accommodate, or has restricted you from doing parts of your job that causes a partial reduction in your earnings. Permanent disability benefits, which are paid when you have a permanent work injury. The analysis that is applied to how many weeks of permanent disability benefits you receive is impacted by what body part is injured. For injured workers who suffer a scheduled injury, the amount of permanent benefits you can receive has not changed. For injured workers who suffer a body as a whole injuries, while these benefits still exist, how much you can receive in permanent disability benefits has changed drastically under the new law. And finally, death benefits, which are benefits that a surviving spouse or child receives when their spouse or parent dies on the job. If you have been injured at work, now more than ever, it is important to call an experienced workers' compensation attorney. Our workers' compensation lawyers have spent hours interpreting the new laws. There are gray areas on how some of these laws are going to be applied going forward, and you will want an experienced workers' compensation attorney on your side to help you navigate these changes. RSH Legal, fighting for fairness for Iowa's injured workers.